Hi, Shanti. As you know, my name is Cynthia Simons, the Director of Women's Justice at the Texas Center for Justice and Equity. We have worked together over the past few years, hyper-focused on keeping families together and reunifying families that have been separated by CPS. We know that family separation disproportionately impacts Black, Brown, and Indigenous families. Black families are at an increased risk of separation. They are separated at very alarming rates, and that has intergenerational effects. If we look at prison data and we look at the foster care data, they very closely mimic each other. So I think that that can allude to the effects of family separation. One thing that really plagues the community is not having the financial support or ability to be able to pay an attorney when you're going through family separation or under investigation with CPS. Will you tell folks a little bit about yourself and what you do?
Thank you so much, Cynthia, and I'm so glad to have you as a partner in this work. As you know, my name is Shanti Khanna, and I'm a Four Girls Foundation Fellow at Texas Rio Grande Legal Aid's Family Defense Project. My fellowship provides direct representation to parents whose rights have been terminated in Child Protective Services suits here in Texas. These parents now qualify for reinstatement of their parental rights in some circumstances, and so I help them file those petitions and the preceding litigation. I'm so excited to be talking about parents' rights today. It's something that I feel really passionately about. A lot of parents don't know that reinstatement is an option for them because the law is so new. So nothing that I say today constitutes legal advice, but I'm hopeful that this information will help parents.
Yes, Shanti, that would be perfect. I think when people get in contact with the CPS system, when they get their child taken away from them, there are very few avenues that they can take without having financial support to be able to employ attorneys where you can fully know and exercise your rights. So I think it would be really helpful if we talked about what rights parents have today. And you mentioned the law being new. So the law that we're talking about is HB 2926 that was passed in the 87th legislature session.
So that law was codified and now lives in the Family Code as section 161.301 to 304. It is a very specific process, and not all parents whose rights were terminated are going to be eligible for reinstatement under the law. It's very specific to parents whose rights were terminated at least 2 years ago, whose children have not been adopted nor are subject to a written adoption placement agreement, and there are some additional requirements that I'll get into as well.
Awesome, that sounds good. TCJE was an instrumental part in getting this bill passed, and the idea of it was born out of formerly incarcerated parents, but all parents who had their rights involuntarily terminated and they meet the criteria that makes them eligible for the reinstatement can access the law. Is that correct?
That's right. A lot of formerly incarcerated parents are eligible, but parents who weren't incarcerated and maybe had their rights terminated for other reasons or causes could also use this law.
Absolutely. Can you share with me a little bit about what parents should know? What are the rights that parents should know when trying to exercise this?
Parents are often told at the time of termination that that final order cannot be reversed or changed. And that was true up until 2 years ago. Now reinstatement does allow that final order to change, and parents can get their kids back, again, only if the kids have not been adopted nor are subject to a written adoption placement agreement. So parents who know that their kids are in foster care still can go back and get their rights. Now, a lot of parents come to my project and say, hey, I don't know where my kid is. It's been years, I've lost contact, I don't know who might have adopted them or whether they might be in the system somewhere. And there is a way to investigate eligibility for reinstatement of parental rights. If it's all right with you, I'd like to take the next couple of minutes to talk about the investigation of eligibility process.
Absolutely, I think that would be tremendously helpful.
On the DFPS website, there's a form that gives notice to the department that a parent intends to petition to get their rights back. You can fill out that form if you're a prospective reinstatement petitioner and submit it to the department ask for a determination of eligibility in response, and the department should provide that to you via email.
And that means that the department would indicate whether you were eligible by saying your child is adopted or your child is the subject of an adoption suit, or you are eligible because your child is not adopted.
The language I've gotten back in response to that notice form generally says this case appears to meet eligibility requirements according to the statute or does not appear to meet eligibility requirements. The department doesn't provide exact information as to what statutory prong, what piece of the law you might render you ineligible.
Okay, that makes sense. What else should parents know?
So I'd like to go through the requirements of the reinstatement law one by one, if that's okay, because there are quite a lot of requirements. It really is a narrow subset of terminated parents who are able to use this law the way that it is currently written. So the first requirement is that the parent's rights have to have been terminated in a suit brought by the Department of Family and Protective Services. So we're not talking about private custody matters here. We're not talking about, one parent terminated the rights of another parent or a family member brought a termination suit. It's really just cases that were brought by Child Protective Services, which is housed within DFPS. So rights have to be completely terminated. That means that if a parent was named possessory conservator, and otherwise if they were given visitation rights at the end of a DFPS suit, that parent likely would not be eligible for reinstatement of their rights. They could go back to court and seek a custody modification, and they should consult an attorney or go to Texas Law Help to figure out how to do so. But reinstatement is really just for parents whose rights have been fully terminated.
Yes, and they also have to have been all involuntarily terminated. Is that correct?
That's correct, and that language often trips parents up because some parents sign an affidavit of voluntary relinquishment at some point in their CPS case, and rights are terminated based on that affidavit that they signed. Those parents, under this reinstatement law, are still eligible because an affidavit of voluntary relinquishment is still considered involuntary termination for the purposes of reinstatement.
Okay, that's really good to know. And are parents required under CPS investigation to sign any type of paperwork that says that they are voluntarily giving up their children in order to access any services or to try to complete something that DFPS is requiring them to do to regain custody of their children?
So an affidavit of voluntary relinquishment is not something that the department should ever be requiring a parent to sign because a parent always has a right in a TMC case to have the judge decide or have a jury of their peers decide whether their rights should be terminated.
Okay, that makes a lot of sense. So there are some other requirements that are with this law, and one of the requirements, I believe, is that the parent has to provide substantial proof for remedying the reason for removal, and that the child also has to have a desire to want to go back home. But if a child has been in foster care and when rights are terminated, parents do not get any access to children, especially if they are in the care, custody, and control of DFPS, how would that actually work in practice?
So I think there's two different pieces here. First is the child consent, and then is the rehabilitation piece. So I'd like to address both separately, if that's okay.
Yes.
Child consent is something that the judge can take into consideration when a child is any age. But if the child is over the age of 11, child consent is necessary for reinstatement of parental rights. At the petition stage, parents are required to provide a summary statement of the child's intent or willingness to consent. And at the end of the reinstatement process, at the time of final hearing, the judge has to find by a preponderance of the evidence that the child aged 12 or older consents to reinstatement. This can be a really big barrier for parents who have not seen their kids and not been able to develop a relationship with them for several years while kids have been in foster care. In cases like that, I generally argue that a summary statement that says something along the lines of parent believes in good faith that child will consent to reinstatement at the end of the reinstatement process generally can suffice. Reinstatement provides for a 6-month period of temporary possessory conservatorship orders where that parent can have visitation with their child and rebuild their relationship to help foster willingness or intent to consent.
Okay, that makes a lot of sense. And in that 6-month period where the court still has oversight, that could be like a transitional period where kid could be with the parent on the weekends, or there could be visits that took place in order to really cultivate the bond that has been broken through systems.
Exactly. My interpretation of that option for a 6-month period is that it's kind of like a return and monitor in a TMC case where the child is given back to the parent, but the department is still involved and that case remains open to provide some oversight during that process.
Okay, that makes a lot of sense.
Although the possessory conservatorship period doesn't necessarily mean the child has to be returned to the parent. It could mean a parent has visitation but no overnights. There is some flexibility in the way that the statute is written so that the judge can render orders that meet the child's needs.
Okay, and in regards to the parent having to provide substantial proof that they have remedied the reason for removal 2 years, at least 2 years prior from the termination. What does that look like in practice?
It can look like a lot of different things, and it's really specific to each case and what the allegations were. Now, a lot of times parents contest the allegations in the initial CPS case. They say, hey, it wasn't fair what happened to me. My rights were terminated based on made up evidence or CPS reports that weren't quite true. The thing about the way that the reinstatement law is written is it's not an appeal where you're going and showing error in the initial suit. You're really showing that your circumstances have changed since that initial proceeding. And that can be hard when parents don't agree with the reasons why their rights were terminated.
That makes sense. And for example, if the situation was the carceral system, what would be good substantial proof that a parent could provide post-release that would make them have a favorable outcome in this type of proceeding?
So the reinstatement law requires parents to show that they have taken substantial steps towards rehabilitation before their rights can be reinstated. This needs to be tailored to the allegations at issue in the initial termination proceeding. So if Child Protective Services made allegations around drug use, and that was the reason why the parents' rights were terminated, rehabilitation could look like attendance at NA meetings or a substance abuse treatment program, maintenance of stable housing and employment. Really, the court is going to look for a change in circumstances since the termination occurred.
Okay, that makes a lot of sense. So for example, if a parent had been incarcerated and that was the reason for removal, it was the actual incarceration, then the parent would be proving stability to be able to provide for the child, not necessarily negating what they were incarcerated for, because it was the actual incarceration, them being confined, that got them separated from the child. So having a job for a lengthy period of time, the same job, making a livable wage that they would be able to provide food for the child, they would be able to provide shelter, they would be able to provide insurance, and making sure that they're not participating in anything that could be linking them or put them in places that were a problem with the reason that they became incarcerated. So making sure that their immediate circle is a safe group of folks and folks that are living productive lives in the community. Would that be fair to say that that would be some of the things that a formerly incarcerated parent would need to provide?
That's exactly right. And I would add to that list making sure that any requirements of probation or parole are completed or working towards completion of those requirements, and just making sure that there's no association with convicted felons. That can be hard when folks who are re-entering are going back to communities where they might have been close with people who also have a criminal history. But in the reinstatement process, the department and ultimately the court is going to be looking for an environment where a child is not around criminal activity.
Yes, that makes sense. And when thinking about preparatory things that a parent would need to do in order to have a favorable outcome in this type of petition, would you say that making sure that they line up mental health care for the child as well as them, even with no knowledge of being able to bring the child home? Would they need to identify the schools? Would they need to identify after school programs? Should parents, prior to filing the petition, already have a game plan in place for all of these things, thus showing that they are prepared and that they have taken the steps to make sure that what they're asking for is a safe environment conducive to thriving with the child?
Absolutely, and it is quite a big to-do list, but accessing any free resources that are available can show the court willingness to meet the child's needs and ability to parent that child as is required for the reinstatement process.
Absolutely. And you mentioned you work for Trella, and you mentioned Texas Law Help. Can you tell us a little bit about what type of resources that parents can utilize from these organizations?
Absolutely. So Texas Law Help has a great website for parents who are seeking reinstatement on their own. So they're filing, we call it pro se, which means they don't have an attorney. You can go to the Texas Law Help website, download a sample petition, and go step by step through the process with their online guide. Texas Rio Grande Legal Aid, the organization that I work for, has a family defense project, and I do reinstatement work as the bulk of my practice. So parents can also apply for assistance through our program. And we can't provide everyone who walks through the door an attorney, unfortunately, but we provide most folks with at least legal advice to help throughout the reinstatement process as well.
Okay, that's amazing. Those are really good resources, and we thank you for the work that you all do committed to families and family preservation and family reunification. Is there anything else that we think parents really need to know when thinking about filing this petition or exercising their rights to have a favorable outcome in the most rural counties and in your more progressive counties? I think what I've heard in my experience with parents is that depending on where they're at, it can look very different, the interpretation of the judge and the willingness from the department for families to be reunified.
Mm-hmm. There are definitely some counties that are known to be friendlier to parents' rights than others. It can be really hard for parents who live in a county that maybe, their local judge is more inclined to side with the department. I will say, no matter where a parent lives in the state of Texas, it is easier to have your rights reinstated if the department is on board. So building a good relationship with your child's caseworker is really important. Making sure that the department sees the steps that you're taking towards rehabilitation. If the department is willing to foster any sort of communication or contact between you and your child after termination, definitely take advantage of that. Make sure that you're not missing visits. Those are all really important ways that parents can ensure success in the reinstatement process.
Okay, and I heard you say really make sure you foster that relationship with DFPS if possible. We know that when DFPS comes in and they separate families, that is a very traumatic experience for the parents and the children. And lots of times parents have experienced family separation intergenerationally in their family, as well as incarceration, if it hasn't been in their immediate family, someone that they know, especially when we're talking about Black communities, when we're talking about marginalized communities. So the likelihood that someone is going to have a great relationship with CPS may not be as high. So what would you say to those parents where DFPS and the parents didn't hit it off and they're still wanting to file this petition? What are the things that they can do to make sure that their child's rights and that their rights are really being adhered to in this process?
Cynthia, that's a really good point. A lot of the reinstatement process is frustrating and counterintuitive in that parents can't show all the ways that CPS harmed their family. They really have to focus on rehabilitation. They have to focus on moving forward. And that's not the most trauma-informed or realistic in a lot of cases, especially for Black and brown families who are disproportionately affected by family separation. So in cases where reinstatement is contested, I think timing the reinstatement petition is really important. Reinstatement is a short process. So when parents file that reinstatement petition, they have 2 months to set a hearing. At that hearing, they can get up to 6 months of temporary orders. But at the end of that max 8-month process, they have to be ready to have their children back in their care and custody full time. And that can be really, really difficult for parents who are getting back on their feet after being incarcerated or recovering from substance use disorder. So making sure that parents are intentional about the time that they're filing for reinstatement, making sure everything is in order and they have the best case possible.
Thanks, Shanti. This has been really helpful. I appreciate you taking the time to talk to me and give our audience some guiding principles on things that would be best utilized when trying to exercise the new law and be reunified with their family.
Thank you so much, Cynthia. I appreciate you having me.